a form of a legal insurrection, ongoing legal insurrection. And it is an insurrection against the laws and Constitution of the United States.
So with this historical context laid out, the main thing I want to dive into is not simply why the administration is threatening to invoke the Insurrection Act, but why they, and particularly Stephen Miller, are using the specific term insurrection over and over.
And it is an insurrection against the laws and Constitution of the United States. Insurrection against the federal government.
You keep using the word. I don't think it means what you think it means.
Despite the fact that Chapter 13 is literally called insurrection, there are kind of two prongs here. One is literal insurrections or rebellions, and the other is that the law can also be interpreted as applying to domestic disturbances that prevent or obstruct the execution of laws. Now, I think it would be less difficult to try to prove that laws are being obstructed than to prove that an insurrection or a rebellion are happening, right? So why has the administration latched onto this idea of an insurrection happening when obstruction of laws is right there? Because even as broad as it is, the Insurrection Act is not the bulletproof carte blanche that they've positioned it to be, because it doesn't allow for the suspension of the writ of habeas corpus.
The Secretary, Noam, what is habeas corpus?
Well, habeas corpus is a constitutional right that the president has to be able to remove people from this country and suspend their right
let me stop you, ma'am. Habeas corpus, excuse me, that's incorrect.
I'm Christine Homeland Security, and I don't know what habeas corpus is.
I think the Insurrection Act is a stepping stone on the path to suspension of the writ. Habeas corpus is a fundamental right. It allows for a person to challenge their imprisonment or conviction on the grounds that their liberty has been unlawfully restrained. It's a way to ensure that individuals are not held indefinitely without due process of law. More broadly, it is the supervision of law enforcement by the judiciary. It's a very important check and balance in our system. And it merits saying, once again, to really hammer this home, the rights laid out in the Constitution apply to everybody in the United States, whether or not they're a citizen, whether or not they immigrated here illegally, whether they're here temporarily. It doesn't matter. If you are on U.S. soil, the Constitution protects you, and therefore you are guaranteed the right to due process. I think the Trump administration wants supervision of law enforcement by the judiciary to go away. They want ICE to be completely unchecked and unrestrained, potentially more than that. They want to use the military and the National Guard as law enforcement, and again, want to do so without supervision or judicial checks. I won't say that the suspension of the writ is their ultimate goal, but I think it is the gateway to their end goals. And the writ doesn't just go away by invoking the Insurrection Act. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So it's a common misconception that we have to declare martial law in order to suspend the writ of habeas corpus. Martial law is a deep rabbit hole. I could make a whole other series of videos on it. So I'm just going to stick with the Insurrection Act for now. Suffice it to say that the suspension of the writ is contingent upon declaration of rebellion or an invasion. An invasion can only be by a foreign nation, so we're not going to talk about that now. We're talking about domestic stuff, so we're going to focus on rebellion. And a rebellion is an outgrowth of insurrections getting out of hand. It is worth noting here that suspending the writ of habeas corpus can only be done by an act of Congress. The president cannot unilaterally suspend the writ. But it's also worth noting that Congress is basically a dog on a leash to the executive branch at this point. I think that their continued use of the word insurrection is part of the administration's larger language propaganda, just like their twisted and incorrect use of the word invasion and war and enemies. Stephen Miller is the chief propagandist for the Trump administration. He's been at the forefront of laying the groundwork for invoking the Insurrection Act. He has been positioning the actions of the judicial branch, who are just executing their normal constitutional role, as a, quote, insurrection. He's asserted that the process of a court ruling that a specific action taken by the administration is unlawful, or even a prosecutor arguing that case, is itself insurrection. He calls it legal insurrection.
Ongoing legal insurrection.
By definition, an insurrection is aimed against the government or the laws themselves. So a part of the government literally cannot do an insurrection against itself while acting in capacity as a part of the government. So that doesn't even make any sense. I want to quote part of an article from the Center for Strategic and International Studies because they put it so elegantly. In a constitutional democracy, sedition and insurrection refer to inciting or participating in rebellion against the constitutionally established government, its processes and institutions, or the rule of law. In other words, in the United States democracy, violently overthrowing the government or its institutions is overthrowing the Constitution itself. One cannot commit sedition or insurrection to, quote, overthrow a government, while still claiming to uphold and defend the Constitution. The U.S. government, the rule of law, and the Constitution are inextricably linked. I think the reason they keep using the word insurrection is to normalize the idea of invoking the Insurrection Act, which opens the door to declaring a rebellion and therefore suspending the writ of habeas corpus. Even though what is happening is patently and objectively not an insurrection and certainly not a rebellion. So what do insurrection and rebellion actually mean in a constitutional context? Insurrection and rebellion are used more or less interchangeably in federal law, but they're not legally synonymous. Case law generally holds that an insurrection is smaller in scale and that continued and sustained acts of insurrection may culminate in a rebellion. But in any event, the administration has latched onto the term insurrection rather than rebellion, perhaps because of the specific title of the Insurrection Act, or the title of the U.S. Code, Chapter 13, and perhaps just because rebellion sounds too cool? On the flip side, it could be that rebellion is too closely associated with rebels in the Civil War and the Confederacy, which despite the fact that they love those guys, they may not see that as bolstering their case. Both insurrection and rebellion fall on a spectrum between dissent, which is patently protected by the First Amendment, and treason, which is very narrowly defined as levying war against the United States. Sedition and seditious conspiracy generally involves conspiracy or advocacy to use force against the government authority, and it is very rarely prosecuted. The most recent prosecutions, of course, were the January 6th insurrectionists who ultimately were pardoned by the Trump administration. Prior to that, there was a case in 2012 that the government threw out because ultimately the guy was just talking some talk and not walking the walk. And before that, it was in the 90s. Insurrection focuses on the act of rising up against the government, the doing, not just the planning. Both of these terms have been defined by courts as being inherently violent. Under judicial precedent, the key ingredients of an insurrection are 1. Intent. The actions, not ideas, but the actions, have to be deliberate and must have the intention of overturning a law or laws by forceful coercion. Next is scale. It has to be organized among enough people and conspicuous enough to garner public notoriety. And finally, the nature of actions actually taken. They have to be violent, forceful, and or armed, and if not presently violent, then imminent and likely to become violent. Insurrection has also been defined in Supreme Court filings under a much softer four-factor test. 1, an assemblage. That could be 10,000 people, that could be 2 people. 2, resisting any law or interfering with the course of a government proceeding. 3, by force or intimidation. That does not necessarily include violence or being armed. It simply means that the mood and the size of the crowd indicates that violence is possible. And 4, it has to be for a public purpose. In other words, it has to be for overturning a law or stopping a governmental action in order to have a tangible effect on the public at large. Speech is protected in a very wide and sacred way in the United States. For example, in Brandenburg versus Ohio, it's codified that advocacy of rebellion or the teaching of related principles or doctrine regarding rebellion is protected speech. You can stand on an apple crate in the public square and scream your head off about how you think that the government should be overthrown. But to be classified as incitement, it must be a present call to action that is imminent and likely to occur. That means you're standing on an apple crate in the public square in front of a large group of people holding weapons. telling them exactly what to do next. But the bottom line is that none of these definitions are specifically codified. Another quote from the article from the Center for Strategic and International Studies. Over the course of U.S. history, these terms have been utilized to find fault with individuals who are merely being critical of the government or a particular party. However, as the nation matured, the U.S. public developed an almost sacred understanding that dissent and even hyperbolic conspiracy and seemingly violent rhetoric can largely be tolerated under the Constitution. So who decides if there's an insurrection? This is where it gets hella muddy. A lot of this is unsettled in modern law. Like I said earlier, because the tenets of the Insurrection Act are not part of the Constitution, they are still up for judicial review at the highest level. As we discussed, the Supreme Court has upheld that the president alone has the exclusive and conclusive authority to determine whether an insurrection is happening. But I want to deconstruct this a little bit. First of all, there's the matter of a person being criminally charged with insurrection versus the declaration that an insurrection is taking place, which inherently means many people are committing insurrection together, an assemblage. Can a person be charged with insurrection if there's been no declaration that an insurrection is happening? Can there be a declaration of insurrection if no persons have been charged with insurrection? U.S. versus Greathouse holds that recognition of the existence of a rebellion may be established by presidential proclamations, congressional acts, and widespread public knowledge. And, not or. This means that an insurrection is so obvious as to be commonly understood by the public at large. It's not a partisan matter. It's not subject to ideology. It's a group of people obviously and violently and presently rising up together against the federal government. But again, this particular test is not codified. It's just something that's appeared in judicial opinions. Whether an individual is convicted on account of insurrection is for a decision by jury. However, we're back in a vicious circle. If a person can be convicted of insurrection, then an insurrection must be occurring, which means the president can invoke the Insurrection Act, which means he's laid the groundwork for Congress to suspend habeas corpus, which means an individual is not guaranteed a jury trial, meaning this person can be locked up on account of insurrection without actually having been found guilty. Now, as we've gone over with the historical evolution of the Insurrection Act and the laws that came out from it, the Supreme Court has historically upheld that it is the president's decision alone whether an insurrection merits the use of the militia or the military or both, and that everybody has to listen to him. Later SCOTUS opinions have softened this a little bit, suggesting that courts can step in if the president acts in bad faith, exceeds a permitted range of honest judgment, makes an obvious mistake, or acts in a way manifestly unauthorized by law. Moreover, SCOTUS has upheld that the actions of the military are still subject to judicial oversight. In other words, federal troops are not free to violate other laws or trample on constitutional rights just because the president has invoked the Insurrection Act. Now, all of this procedural interpretation is much more subjective than this makes it seem, and it needs to be contextualized in a broader judicial framework. I could get really deep into this with presidential powers and the four-zone test, but I'm going to table that for another video. The bottom line is that the Trump administration is using propaganda, disinformation, misinformation, and outright lies to lay the groundwork for the invocation of the Insurrection Act. Their ultimate purpose is for Congress to declare rebellion in order to suspend the writ of habeas corpus. That is the worst case scenario. But everything leading up to it is also bad. What are normal checks and balances, which are the backbone of American constitutional law and the federal system of government, they are characterizing as terrorism and rebellion and even treason against the United States itself. Stephen Miller has called any member of the judicial system who doesn't fully align with the administration's priorities and actions terrorists. The administration holds that Trump is the United States, and any opposition to Trump is in fact opposition to the United States itself. That is textbook authoritarianism. Miller further said, and I'm quoting him here, "The only remedy to terrorism is to use legitimate state power to dismantle terrorism and terror networks." And in this case, by legitimate state power, he means plenary authority over the military under the Insurrection Act. To put it explicitly and bluntly, The Trump administration wants to use the U.S. military against any U.S. citizen who dissents against the official positions of the executive branch. Potentially half the country could be labeled terrorists and insurrectionists. With such a broadly defined population of insurrectionists, it would be nothing to declare a rebellion. And then anyone who says anything against the president can be thrown in jail indefinitely without trial. And that's it. That's all she wrote, game over. And when the Insurrection Act is invoked, the Posse Comitatus Act no longer applies to the military, and therefore the president has access to over 2 million uniformed service members who can act now as domestic law enforcement, enforcing his will as the law. Combine this de facto martial law with the government's recent pattern of misplacing detainees and Pete Hegseth's obsession with lethality, you see where this is going. I want to quote here from an essay called Calling Forth the Militia, A Brief History of the Insurrection Act. For the last 3 decades, presidents appear to have accepted that calling in federal forces is a measure to be saved for truly grave crises for which there is no serious dispute over the need for federal intervention. That's where we landed when we were still in the land of norms and standards. The powers granted under the Insurrection Act law are not inherent to the Constitution, and thus they are subject to continued judicial review and legislative action. These are not set in stone, and a big reason I'm doing this video is so that you guys get all hyped up that we need to change this law before it's too late. Protest and dissent are comprehensively protected under the First Amendment. However, acts of sedition, seditious conspiracy, and insurrection actively damage the United States system of government, with the ultimate consequence of depriving other citizens an equal opportunity to participate in democracy and effect responsible change. Freedom of speech in nearly all forms is an essential part of U.S. democracy. But to maintain these freedoms, we need to protect and preserve the Constitution and the institutions that it establishes, not because they are perfect, but because they are capable of change through peaceful means. If you made it this far, thank you, thank you, thank you. These videos take a lot of effort. If you like this and would like to see more, please do all the usual things. Like, share, subscribe, leave a comment. I am a communications professional, designer, and artist. I started doing these videos as a way to help myself think through some of these complicated issues that are affecting us right now. As an artist, I am a very visual thinker, and a lot of times turning concepts into little icons and being able to move them around on the page is a very helpful way for me to wrap my head around things. And I thought maybe it might be useful to other people too. Thanks for watching. Bye.